That's when I started realizing maybe, and I said it to one of our colleagues even this morning when we were having tea, that it appears I sort of found myself in an offside position, or at least handled a ball with my hands. In fact, I sort of feel a little bit angry if I think about it, that it feels like I was set up. Not only me, but Hlachwayo as well. I think junior as she was, I don't think she was supposed to have been involved in this case. And looking at it now, it appears to me she was set up.
But I think you are being unfair to yourself. You are still going to come to this later in your statement. You have placed before us an annexure in which you actually questioned the merits of the case, and you prepared quite a lengthy document raising a number of concerns that you had about the merits of the case itself. Of course, I'm sure that what you are talking about now is possible impropriety with regard to why the case was investigated in the first place. I'm sure that's what you are talking about. But it's not as if you just gobbled up everything, every and anything that was placed in front of you.
Indeed, Commissioner.
Chair, I see the time, and we are about...
For you, for such a big matter, we're talking head of crime intelligence in the country and other generals at SAPS.
Commissioner Kumalo, it was a concern, and that is why I asked to go to court to assist. But I did not think of involving myself beyond that that point after the bail application was done, because I did not know why is this team so small. I did not know how it came about, but what I know is a case cannot be handled or done in the Idac without the ID knowing. Therefore, I don't know how this team was composed, but honestly speaking, I didn't want to get myself involved in why was this done, why was not, because I was not part of the team at the time.
You give the impression that you did not want to step on the ID's toes. You did not want to ask her difficult questions. So you said, if she made the decision, I will live with it. I won't even question it. That's the impression you are giving me.
And I'll agree to that, Commissioner. Because as the head of the office, you would have made decisions. I can't ask questions on, especially questioning how this team was composed, why not involve me, or why not involving Advocate Polo, who was overseeing this. At the time, I didn't ask myself many questions on the composition of the team, but it didn't look right to me that a case of this magnitude was, on the day of the arrest, handled by a junior. I didn't take it further than that, but it didn't look right.
Sorry, you say in paragraph 34 your involvement ended after the court appearance, but I don't think you mean end, because in paragraph 35 you say you were called to a meeting on the 8th of August, and at that meeting the ID informed you that she had decided to include you in the matter. So it was not end forever.
That is correct, Chair.
So there was an intervening period during which you were not involved. That is after the court appearance in June, and then in August you are brought in by the ID herself.
That is correct, Chair. I'm saying my involvement ended there with the bail application because I was not part of that team. I was not supposed to be part of the team. I went there and helped with the bail application, and my involvement in as far as they ended there.
Yes.
But coincidentally, about 2 weeks after then, I'm called for a meeting where I'm formally then involved or designated by the ID into the matter. After the bail application, I did not work on this case. I did not discuss it. I continued with my work. I'm overseeing a group. I'm also having my own cases. I'm doing it. I concentrated on my work. I forgot about this case until on the 8th, when I was called to a meeting by the ID.
The 8th of August.
On the 8th of August, and which is then on paragraph 35, on or about 8 August.
Maybe before you discuss, you go to paragraph 8. Let me ask my question, and again, it goes back to wanting to understand the reporting and role of Mr. Sissoko. You have this experience now on the 27th of June, and you note all these wrong things about it. Isn't that typically something that would have had to go into the discussion? Because part of it sounds like resource allocation, right? Isn't that something that would have typically gone into the reporting to the, is it OMC or something, when you make those monthly reports and get it addressed there? Is that not?
I agree, Commissioner. It's something that ought to have been raised in that structure. I'm not sure if it was at the later stage, but from the date of the bail application when the case was postponed until up to the 8th, I don't remember. I don't think we had an OMC. But these are type of issues that are dealt with in the OMC. Resource requirements, where there's shortages, and even these challenges that how is a team dealing with such a big case and there's no deputy.
So you say you don't remember whether it was raised or that you had a meeting after that. Is that?
That is correct. Between the 27th when the case actually, and evidently overwhelmed. The court was about to commence, and the J15, which is the administrative form to which the charge sheet is attached, had not been completed. There being some 7 accused involved in the matter. Advocate Vedboy obtained the necessary J15. I remember she literally rushed to the clerk of the court, brought a blank form. I then took the docket from Mr. Parayashe. I then started reading out the names of the accused as they appeared in the docket to Ms. Vedboy, who was then, to Advocate Vedboy, who was then completing the J15, which was then handed to the clerk to register the matter on the book. Our assistants enabled Advocate Tlatrayo to consult with the defense legal representatives. The courtroom was full of police officers, family members of the accused, and members of the press. Advocate Vedboy and Shikovi obtained seats at the back of the court. As there was nowhere else to sit, I then sat in front next to Advocate Tlatrayo. And Mr. Parayashe, the investigating officer, was seated directly behind us. I was not the prosecutor in the matter. My colleagues and I attended solely to support Advocate Tlatrayo. The proceedings commenced before the magistrate, Mr. Madlanga, whom I did not know and was seeing for the first time, their bail applications by reading their client's supporting affidavit into the record. At various points, Advocate Tlatrayo experienced difficulty in answering questions from the court and conferred with me and with Mr. Parayashe, who was seated behind us. In the course of dealing with the bail application, Advocate Tlatrayo asked the court to impose a condition that the witnesses not be contacted or interviewed by the accused. The magistrate indicated that he required a list of the witnesses, as he could not simply warn them, and he appeared not to be satisfied with her response. The magistrate then invited me to address him, observing that I appeared to be from the same office. And maybe just to add here, Commissioners, I remember he precisely said, because they were engaging with Advocate Tlatrayo, and he then looked at me and he said, okay, let the gentleman seated next to you address me. He appears to be from your same office, because now and then Tlatrayo kept on talking to me and at the same time with Mr. Padayashi. And that is why the message said, let this gentleman address me. Before doing so, I then asked Padayashi whether a bail statement or affidavit had been prepared.
What is a bail statement? What would you find in there?
Commissioners, this matter, as I understood at the time, fell under Schedule 5 of the Criminal Procedure Act. And Schedule 5 and Schedule 6, these are serious matters. Schedule 5, the accused to be released on bail has to bring an application and satisfy the court that it is in the interest of justice that he be released on bail. What we do as the state, to avoid the investigating officer to testify viva voce in court, he then compiles an affidavit setting out even if the state is not opposing, the reasons why we are not opposing. For example, we would have verified the addresses of the accused. The statement will state, we've checked their criminal records. They don't have criminal records. They are not a flight risk. They are gainfully employed, and all those kind of issues, they will come into the statement. We either do that by way of an affidavit of the statement, or the IO has to go into the box, and as a prosecutor, will then have to lead him to cover all those aspects.
And you say that's something that happens as a matter of course with Schedule 5?
It has to happen. I know, Commissioner, that there are instances where the state is not opposing, even when the state is not opposing bail, and the prosecutor addresses the court from the bar saying, we're not opposing bail. I know of instances where the courts would have insisted at least on some form of evidence, formal evidence from the state.
You told us that if someone were to be taken from a deputy by another deputy, there would be a discussion between the deputies. Obviously, from what you say here, nobody had approached you and asked that Advocate Hlajwayo be part of the prosecution in another group or team. So, as I say, so that's another kink, or that's another anomaly.
Indeed, Commissioners.
And I also see the name of Mr. Brian Padayachi. Was he not a senior investigator in your team?
Padayachi was not in my team.
He was not in your team?
Yes, I think he was in the security cluster.
Someone else's team?
Yes.
So it looks like
But it was strange that a junior prosecutor was reporting to me is allocated to this case without me having been engaged. Not that it doesn't happen, like I said, I would have expected, say, maybe Advocate Paul Lowe, if he was part of that group, to have discussed the matter with me, to say, we need a prosecutor, we're having a shortage. Do you have a lot of work for Joy? If I said no, then we agree they can utilize it.
And was this the right team for, or rather, was this the right case for Mr. Padayachi? Or was he too misplaced, as it were?
He's a senior criminal investigator, Chair. I would believe he was suited to
no,
be part of this.
I'm asking in the context of the different groups. For example, Commissioner Baloyi said this was an intelligence matter which would have fallen under deputy law. Yes. So did Mr. Padayachi work under deputy law? He
was working under advocate law.
Oh,
he was in the security cluster, which was headed by advocate law.
That's what I wanted to
The only amazing thing is that advocate law appeared also not to know about this case, because I saw him in the office that morning.
Yes.
He was not properly dressed for court, or at least that he knew about the case.
So when you inquired, what case is this and what have these generals been arrested for, he too did not respond and say this is what happened and this is why they were arrested. He appeared to be in the dark as well.
He appeared to be in the dark like I was. He did not know about the case.
Okay, Serunye, ordinarily who allocates matters to junior prosecutors in the Idac? So take, for example, Advocate Hlachwayo, who ordinarily allocates matters to prosecutors at A level? Is it the ID or is it the DDPPs?
It will be me. It will be me as the DPPP in that group. I'll look at the setup of the team to say, I need, say, maybe one or two juniors. Let me go for Advocate Hlachwayo and so and so.
Can Mr. Sissoko allocate a matter to
No,
a junior prosecutor?
That doesn't fall within his
So
mandate. and powers.
ordinarily, only a DDPP would allocate a matter to a junior prosecutor.
That is true, Commissioner.
And
Only
if it's a junior prosecutor in your team, you would be the one allocating.
Indeed. So that is so, Commissioner.
I think you were to...
And in this case, that is why I found myself asking a lot of questions because I didn't know about the case where one of my juniors is involved. And, but I understood that because we signed these non-disclosure forms, maybe that has happened and I was not involved. But it was something didn't sound right. It was a bit strange.
I think you were to start I established that she was appearing, or am I
Yes,
mistaken?
I then established that Advocate Hlachwayo was appearing in court that morning with investigating officer Mr. Brian Padayashi, and that there was no co-prosecutor with her in court, no senior state advocate, no DDPP, and no chief investigator assisting her. I was concerned that a matter of this magnitude involving the arrest of senior members of the police was being handled without such support and without a DDPP overseeing it. At that moment, yes, I then, together with one of my fellow DDPPs, Advocate Jacinta Vetboy, and Mr. Sibusi Sochikovi, who's the chief financial investigator. These people, I'm mentioning them because they were in this group when we were inquiring and making and trying to find out who was handling this. We then decided, the three of us, to approach the head of the unit, the investigating director, Advocate Johnson, to request permission to attend court to assist Advocate Hlachwayo. On arriving at her office, we found that the investigating director had not yet arrived, and we left a message with her personal assistant, Ms. Innocent Sikukuni. On my way back to my office, Ms. Sikukuni telephoned me to say that she had discussed our request with the investigating director telephonically, and that the investigating director had agreed that we could attend court as requested.
Did you ask or did you find out who and how Ms. Hlachwayo came to be allocated? Who selected her?
Yes. I only came to know afterwards, commissioners. I asked and I was told, and the information I got was that she was appointed by the ID. And I was told that initially the only prosecutor in the matter was Advocate Ramsemi, Drew Ramsemi, and that Hlachwayo was then also allocated, or at least designated to the matter around May, so earlier, just shortly before the arrest in this case.